opinions. I am very happy that today we have a lot of learned participants in this program, very senior insolvency professionals. I am very happy. More than sharing, a small little amount of knowledge and experience which we have gained during the last 4 or 5 years of being in this profession, I would expect a lot more interaction and a lot more contribution from the participants, because I see a very, very senior, array of professionals here, and it would be very nice that you all share your, the knowledge which we have gained in this. So the participants, I would like to request one small kind of, additional information I thought I can share with you. We will start with a brief presentation on the topic of, the liquidation and the important decisions on liquidation matters, decisions by Supreme Court, NCLAT, NCLT, and other forums. In this process, we have a good team. Our team has made a lot of efforts in the last few days to put together some of the important decisions. And I also have my fellow senior insolvency professional, Mr. Nageshwaran, also on the screen. Thank you, Mr. Nageshwaran, sir, for joining.
Thank you, sir.
And also my team. Thank you, sir. Thank you. And also our team consisting of Ms. Mekhala and Mr. Raghu and Ms. Anusha, also Ms. Ilamati. So all of us are here to share the limited knowledge, limited information which we have gathered on this particular topic. And it would be great, going forward, we debate on these important decisions. Towards the end of the session, there will be a kind of interactive sessions with question and answers. So I'll be greatly obliged and deeply grateful to all the participants, so that we will be able to have a very useful interaction on this day. Gentlemen, ladies and gentlemen, this Raghu, can you please show the presentation?
Yes.
Okay, as we get ready with the presentation, a few slides, I would like to quickly trace the liquidation process in IBC, how this process has gained more importance. The very preamble of IBC, when it was enacted, does not contain the word liquidation. As the senior insolvency professionals, definitely they know that many of the courts have quoted the preamble in their decisions. Whenever there is a kind of a push towards liquidation, first they will say, have you exhausted all your available resources, available avenues, available remedies to resolve a company before you push that company into the slaughterhouse, before you push the company into liquidation. The very purpose of the preamble itself will say that resolve the company, resolution process for a corporate debtor, so that a lot of economic benefits will accrue to the society, and there will be balancing of interests, promoting of entrepreneurial progress, and also the reordering or readjustment of the order of debts under a recovery process, section 53, the waterfall mechanism, whereby the government will not take the first priority, the sovereign debt, but they would like to go down in the pecking order. So they will go to or serial number 5 in the distribution process under section 53. So that being the push by the government, to go more on the road of resolution rather than the road of liquidation. Now, you might be knowing very well that at the beginning of the IBC, when it came into existence, a lot of cases got transferred from BAFR and AIFR. So the cases pending before BAFR were all cases where nothing could be done. So those cases came into IBC. Eventually, they found way into liquidation. So that's one of the reasons. If you take that today, about 4,000 cases of insolvency admission into CIRP, out of them, more than 2/3 would have gone into the liquidation process. The resolution process would have been much less. In between, there are certain withdrawals, there are certain settlements, there are certain other court matters by which the cases get fully dissolved. But the liquidation matters may form a major chunk of the insolvency cases filed before the NCLT. If that is the case, what is the final solution in the liquidation process to release the assets so that the realization of the assets entangled in the liquidation process is released and the creditors are getting whatever money, whether they get 1% or 0.5%. Nowadays the sacrifice has been huge. It has gone to the extent of even 90-95% sacrifice has been taking place, and the lenders are also aware of this particular scenario. I think they just go by the market trend. Am I going to recover X amount today? And whether I'm going to recover X plus in the liquidation process, let me go ahead in the liquidation process. So that's how the economic equations are happening. So that being the case, the provisions in the liquidation, there was a provision of the stakeholders. How the stakeholders will act in the process of liquidation and advise or help the liquidator in the process of liquidation. So it was a purely an advisory role for the stakeholders. Regulation 31A, which was introduced, by which a stakeholders consultation committee was to be formed. Now the stakeholders consultation committee has undergone a lot of changes, tremendous changes. Suddenly the contours of stakeholders committee is completely revamped very recently by an amendment by which a lot of powers have been given to them, not necessarily to decide but advise the liquidator. So the powers have been, the advisory roles have been widened in the process. Well, that is one aspect of it. The other aspect of liquidation, how the contours have been changing over a period of time, is that Section 230 of Companies Act, how that interplay happens between IBC and Section 230 of the Companies Act. And another important relevant aspect is the sale as a going concern concept, which has again taken center stage in the liquidation process. Before you consign the company into the the box, the graveyard, before the coffin gets nailed, please try once more to sell the company as a going concern. That's again another attempt by the government. Regulation 32A, sale of company as a going concern, even in the liquidation process. So all these things have added to the kind of the diversity, the dynamism in the liquidation process, so that finally the realization of the assets and maximization of the assets take place. You may all be aware that there was one provision which was introduced, which is NRRA, not readily realizable asset, how the liquidator can get rid of them, whether they get sold or they get assigned. Finally, the liquidator says that I can't do anything with this kind of assets. Let me say goodbye to this. Someone of you will please take care of this asset. So these are all some of the provisions which has come over a period of time in the liquidation process. And the last but not the least, definitely an important one, the relevance of Section 12A in liquidation. The 12A talks about the withdrawal process, essentially during the CIRP process, but a few cases have come up even in liquidation, and very notable one among them, which we will also quickly highlight in our subsequent discussions today, is on Vallal RCK, which is famous Sivasankaran case. I think recently you would have seen a decision by the High Court that the traveling abroad by one of the promoter directors has been curtailed by the Chennai Madras High Court. So this being the situation today, the liquidation which existed in 2016 when IBC got introduced and the liquidation process today in 2023, I think there is tremendous change, metamorphosis has taken place in this period. And with that initial introduction, I am glad that our team will be sharing a lot of insights into this. Definitely, with one more request to the participants that please take a note of what all the points you would like to ask the questions for the sake of quickly concluding the presentation, and then later on we can spend a little more time on the question and answers. So with that introduction, I now request Mr. Nageshwaran, who has been well experienced in the entire CARP and administration process. He has been a very rock solid support extending to our team in various matters, including some very complicated cases. So, sir, Mr. Nageshwaran, would you like to quickly address the participants, the relevance of the changes in the liquidation process, and also how the courts have been taking kind of not all the time they have played by the book. They have also taken sometimes a different kind of decisions in the interest of releasing the liquidation assets. Thank you, Mr. Nageshwaran. Thank you.
Thank you. Thank you, Mr. Rajenderan, sir. As you rightly told in the last 2-3 sentences, liquidation over a period of time, particularly after our Justice Mukhopadhyaya introduced the very bold idea of bringing in Section 230 into the IBC. So, I mean, that at that point of time, all of us were taken aback. What is this happening? Now, how come this is going to be a different thing? And are the authorities are going to allow a backdoor entry by somebody else into the entire matter? And this is going to be a real fox pass in the entire situation. But on a retrospective thing, if you today think about it, that was one of the bold steps which were brought in by the judiciary into the code and got it stabilized by way of amendment. And finally, Section 230, not only Section 230, as Mr. Rajenderan told, all the other things, whatever have been happening, including allowing OTS, allowing 12A, allowing whatnot. And even one case, as he was talking about, after we even declared the asset as a not readily realizable asset, and almost everything was made ready to hand over the asset to one of the creditors, the company was revived and a 12A was submitted by the promoters. And that was also finally accepted and finalized, and the entire thing, I remember this case was almost for 4 years. After 4 years, after liquidation itself, after 2 years, the account came into 12A and it was settled out. We probably will be hearing about this case in our presentations. Like that, see, what personally, what I could see here on that is liquidation is one area where we as liquidators, insolvency professionals, should also think out of the box and help the judiciary to think out of the box and to find out, instead of finalizing whatever may be the realization, finally, instead of putting it as a liquidation stamp, how fast and how quickly we can convert that into a situation of bringing it back to CARP. Technically, this, which is not supposed to be having originally as an idea, but now everything is kept so merged. Now CARP confirming into liquidation and thereafter again bringing it into 12A, taking settlements. Actually 12A not being a matter in the liquidation area anywhere, but it has been brought about now. So everywhere we have been, particularly the liquidators have got a good job on hand to think about how to move in that area, and anything in this area is always welcomed by any judiciary setup that, okay, why not we try this? if it is going to be taken out of liquidation and at the same time, a quick resolution is going to be possible. Because we find that even in liquidation, after the asset is auctioned and things, thereafter, a lot of things come up and we are not able to really close the matters. And there are so many times after the order liquidation is over and that is auction is over, but the finality is not taking place. So these are all things which have gone into the minds of the judiciary. And so they are ready to hear from the insolvency professional, whatever a change you want to bring about, think of it, we will bring it into the system and ensure that the account is taken back to normalcy and closed out. This is the model that is being talked about, and it is one of the important area of liquidation as we find it, because for CARP, you have got all tight bound, tight sites, everywhere you are put in a box and you are not allowed to move here or there and things. Here you have got one SCC, which again, maybe because of the unlimited powers, whatever liquidators were once upon trying to push into the matters, but they were not finding a solution. Through SCC, now things are all being moved out. Even I don't know, maybe during the discussion, some of you, as Mr. Rajenderan told, seniors in this area, the seniors than both of us also might be having a thing to say. But this one question on that is, now when it is under section 230, and when we have brought about to that extent everything, how you are going to allow, because you are not having as a liquidation, you are not having the balance sheet drawn. You are not having any except the valuation on a new system as per the IBBI. If it is required by the SEC by a decision, you are taking it up. But there is no balance sheet. There is no thing. Now, after the company is sold as a going concern, the person who is taking it over, where from he starts? 3 years back balance sheet, or how is it going around? Because in between all items are all, as you know, it is only income and expenditure statement audited and submitted. And this is one question which is, to my mind, has not been answered in any of the cases. Like that, many practical things are all there, but still liquidation turning into CARP or getting into a situation of closure, not under the liquidation rules and regulations, is one important area and interesting to continue. With that, I would like to hand over the session back to Mr. Rajan.
Thank you very much, Mr. Nageshwaran. Ladies and gentlemen, one small information I thought I can share. Mr. Nageshwaran, if someone of you can guess his age, I think definitely I will put something like 60, 61 for him. But the reality is he is 70 now. And by virtue of his age, I think IBBI, prevents an insolvency professional who has reached 70 years of age, from getting an AFA, authorization for assignment. Nevertheless, I think Mr. Nageshwaran has kept himself very busy, and in fact, I would like to say that he has appeared for insolvency exam in US, American Bankruptcy Code, and very soon probably I think he may be practicing in US. Good luck to you and all the very best to you, Nageshwaran sir.
Thank you, sir. Thank you.
Thank you. Thank you very much. I would like to start the presentation now briefly, and then, can you please present it? Okay, this is the kind of, what we are going to discuss today, the liquidation, important case laws on liquidation matters. Next. The roadmap, the kind of broad areas in which we are going to analyze and, dissect the decisions and, come to some kind of observations and the important essence of the decisions. Broadly, section 52 and 53, the waterfall mechanism, that is where the secured creditors always have, different views, differing kind of interest. Somebody says that my interest is priority, I have more secured asset, as security, the other guy is not having that much value of assets, whereas you put both of us on the same platform. So these kind of decisions, some of the areas have been decisions have come out in the liquidation process. 21A, security interest, how to prove the security interest, number one. Number two, most of the secured lenders would like to cling to their asset and then say that I will first realize the value out of it, and thereafter, if I'm not possible to sell, then I will hand over the security interest, I will relinquish it. But many cases, a lot of litigations have happened. I have seen cases where more than 2 years, 3 years, the secured lenders have kept themselves the assets without relinquishing them. And finally, some orders have come, favorable orders have come, in spite of some time loss. Deduction of TDS, there are some cases where the liquidator sells the assets, the value being more than 50 lakhs. Where is the requirement and the reduction of 1% amount of TDS? So there are certain cases on that. Stamp duty at the time of sale of the asset, the liquidator issues the sale certificate, and whether the sale certificate requires to be registered with the sub-registrar office, whether stamp duty is applicable on such intimation to the registrar office. So there are some case laws on which we would like to highlight. 12A, of course, we talked about this withdrawal of the application under section 7, 9, and 10. And lastly, the section 230 of IBC, compromise and arrangement, how that interplay is happening and how the courts have taken different decisions. And finally, whether the scheme approved by the NCLT has seen the light of the day and whether it has been successful, the company is back into operation, back on track. These are all the broad areas. And I have my colleague here, Mr. Raghu, available with me. And Mr. Raghu, can you go to the next slide, please? Yes. Sir, Raghu, you are available.
Yes.
What is the next slide? Raghu, would you like to start with the first item on the case law?
Yes, sir.
This is the one which you would like to handle, right?
Yes, sir.
Yeah.
So before going into welcome to all to the webinar. Before going into the case law directly, I would just like to introduce that initially the code enabled the secured creditor in liquidation proceedings under section 52 either to relinquish its security interest in the manner specified in section 53 or realize its security interest in the manner specified in section 52 of the code. Further, regulation 32 of the liquidation process regulations prohibited the liquidator to sell an asset which is subject to security interest unless the security interest therein has been relinquished to the liquidation estate. Initially, the code, however, does not provide for any timelines for opting to relinquish or exercise security interest. This has created a lot of issues, and because of that, the liquidation process went on to the courts and other things. One of such cases is this Srikanth Dwarakanath, liquidator of Surana Powers Limited versus Bharat Heavy Electricals Limited. Thereafter, consequently, the regulation 21A was inserted to fill this gap by the amendment to liquidation process regulations with effect from 25th July 2019, wherein the timelines for the secured creditor to decide on the relinquishment, realization of the security interest, contribution to the liquidation cost in case of deciding to realize its security interest outside the liquidation estate, and the consequences of non-compliances of the regulations were provided in the regulations. Now we'll go into the case law directly. See, in this case, NCLT based upon section 13(9) of the SAFASI Act decided on realizing the security interest of the secured creditor under regulation 21A of the liquidation process when one of the secured creditor refuses to relinquish its security interest in secured assets during the liquidation process. I will just brief the facts of the case. During the liquidation process of Surana Power Limited, the liquidator faced a deadlock when secured creditors 10 out of 11 having 73.76% share in security interest relinquished their security interest to the liquidation except one secured creditor, namely BHEL, with 26.24%. As pointed out earlier, the regulation 2 of the IBPA liquidation process regulation that where an asset is subject to security interest, it shall not be sold unless the security interest therein has been relinquished to the liquidation estate. The liquidator was unable to proceed with the sale of assets without the consent for relinquishment of security interest from all the secured creditors to whom the said asset was charged. He filed an application before the AA seeking permission to sell the assets of the CD. AA rejected the application, stating that an arbitration award has granted lien over the assets of the CD to BHEL prior to initiation of CRP, and BHEL is entitled to proceed under Section 52 of the IBC to realize its security interest. Against the NCLT order, liquidator filed an appeal before the Honorable NCLAT. Honorable NCLAT, while deciding on the case, relying on Section 39 of the Sarfasi Act 2002, which requires confirmation by secured creditors having at least 60% of the value of the total debt for taking any steps about the realization of the assets by secured creditors, observed that since BHEL did not have requisite 60% value in security interest, it did not have the right to realize its security interest. It also observed that since secured creditor with 73.76% in value have already relinquished the security interest into the liquidation estate, it would be prejudicial to stall the liquidation process at the instance of the creditor who has share of only 26.24%. While allowing the appeal, the NCLT further observed that BHEL did not hold a superior charge over the rest of the secured creditor, and the decision of 73.76% majority creditors would bind the dissenting secured creditor. However, this case was further appealed with the Honorable Supreme Court, and Honorable Supreme Court on 11 September 2020 stayed operations of the NCLT order. So this case stands as on that date as it is. It is pertinent to mention here that IBPI wide discussion paper on strengthening the regulatory framework of liquidation process dated 27th August 2021 highlighted this situation and proposed amendment to the regulation to the effect that if the secured creditors having 60% of value in the secured debt desire to relinquish or realize the security interest, such decision shall be binding on the other pari passu charge holders. The status quo is this.
Okay. Good. Thank you, Raghu. I think this is one important case where, the clarity amongst the secured lenders, someone, trying to say that I would like to hold on to the asset, I will not like to relinquish. The Supreme Court has to come with the final decision on this matter. Okay. Good, Raghu, thank you for that. I think the next case law on which we would like to discuss is Dhanalakshmi Bank versus technofab manufacturing. I think this is also bordering on the same section 52 and read with regulation 21A, wherein there is clarity given by appellate tribunal. Good that it has not been challenged again in the Supreme Court. Raghu, you would like to talk about this now?
Yes.
Yeah, please go ahead.
So in this case, Dhanalakshmi Bank Limited, the appellant, being the secured creditor in the liquidation process of the corporate debtor, that is Technofab Manufacturing Limited, has intimated the liquidator to realize its assets over which it has exclusive surcharge under section 51, subsection 1, clause B of the IBC, and in physical possession of the asset. The order of liquidation was passed on during September 2018, and the physical possession of the secured asset was handed over to the appellant by the liquidator during September 2019. The first auction of the secured asset was made during September 2019, and thereafter, after a gap of 15 months, the second auction was held during January 2021. As the asset was not realized by Dhanalakshmi Bank, the appellant, for a very long period, liquidator has asked the appellant to vacate its physical possession and return back the assets to the liquidation. The appellant intended to put further efforts to realize its security and accordingly needed a further time period of 6 months. However, the adjudicating authority dismissed the application. Dhanalakshmi Bank therefore appealed against the NCLT order with the NCLAT. It was contested by the liquidator. The appellant has not taken any effective steps to realize its security interest for nearly 2 years. NCLAT upheld the decision of the AA and held that in the present case, the order of liquidation was passed in September 2018 and 3 years has been lapsed and the liquidation proceedings could not be completed. Even after granting ample opportunity, the appellant has failed to realize its security interest for nearly 2 years. Therefore, the adjudicating authority has rightly directed the appellant to hand over the assets in possession back to the liquidator within 7 days. The appeal was dismissed and the Honorable NCLAT find no legal flaw in the implemented order.
Okay.
So we have confronted a similar situation where we have dealt with regard to in our own cases also.
Yeah.
These kind of problem and a lot of time have been lapsed.
Correct.
Due to this gap in the legislations.
Yeah. Thank you, Raghu. I think what Raghu is trying to highlight is that in one of the cases handled by us, we had to go to the extent of even initiating contempt application against one of the state, public financial corporation, which did not relinquish the asset or which they did not give it back to the liquidator and they had clung on to it for more than 2 years. And finally, after initiating the contempt application, we were able to get possession and we were able to sell the asset, realize, and then distribute it. Okay, as we progress in this session, one reality check. Mr. Amresh Sood, can you hear me, sir? Mr. Amresh Sood?
Yeah, I can hear you.
Okay. Just wanted to check whether we are audible to you. The audio quality is good. Is it okay?
Yeah, it's good. Okay, I can hear you. I'm listening to you.
Very good. Excellent, sir. Mr. Shankar Varadarajan, sir, can you hear us? Renu Agarwal? Okay, doesn't matter. Sir Nageshwaran, sir, I think we are able to hear.
Yes, sir, very much. We are able to clearly.
Okay, very good. Okay, now moving on. what is the next case we are going to talk about? This is regarding, an issue with the Chief Commissioner of Income Tax regarding this, deduction or remittance of 1% TDS on sale of assets under Section 194 IA of Income Tax Act. Please go on.
Yes, myself.
Okay, Mr. Raghu, would you like to quickly, share with the audience the final decision on this matter?
Yes, sir. In this case, the Honorable NCLAT has held that the successful bidder, the purchaser of the property in an auction sale for the asset of the corporate debtor under the IBC shall not be required to remit 1% TDS deducted from sale consideration to the Income Tax Department under Section 194 IA of the Income Tax Act 1961. The Honorable Tribunal also observed that the liquidator is not liable to file the income tax return of the corporate debtor under the code. The Honorable NCLAT in this matter dealt with the interplay between the provisions of the Income Tax Act and the IBC while deciding the overriding effect of Section 238 of the IBC in a situation of inconsistency between the sections of the Income Tax Act and Section 53 of the Code. The brief facts of the case are: during the liquidation proceedings of the corporate debtor S. Kumar Nationwide Limited, the successful bidder in the auction held for sale of assets of the corporate debtor deducted 1% TDS from the sale consideration and remitted the balance to the liquidator. Liquidator filed an application seeking direction against the successful bidder and the income tax authority not to deduct TDS from the sale of assets made in favor of the bidder on the ground that tax dues cannot be collected by the government in priority to the waterfall mechanism under Section 53 and Section 238 as overriding effect upon other enactments. NCLT dismissed the liquidator's application and made the following observations: that there is no provision that exempt the successful bidder from deducting TDS from sale consideration payable to the seller. Section 238 does not create an overriding effect in case of TDS deduction. The deduction of TDS under Section 194 IA of the IT Act is not inconsistent with the waterfall mechanism of recovery of claim mentioned under Section 53 of the Code, considering deduction of tax under Section 194 of the IT Act does not tantamount to payment of government dues in priority of the creditor, because it is not a tax demand for realization of tax dues, and that it is the duty of the purchaser to credit TDS to the Income Tax Department. Aggrieved by the NCLT order, liquidator filed an appeal before the Honorable NCLAT on the ground that whether the provisions of liquidator filed an appeal before the NCLAT. The question before the appellate tribunal was whether the provisions of the Income Tax Act are inconsistent with Section 53 of the IBC. So we would I would like to point out that during August 2020, IBPI for the purpose of education and awareness of the IPI, wide facilitation in aid to IPI conducting the liquidation process, provided some case laws for reference and understanding.
Okay.
In that particular, this NCLT decision would have come, and further, this appeal was not presented there. So we just want to highlight here that there is a further development in the case. NCLT, after analyzing the provisions of the IT Act and the IBC, held that the code and the regulations are silent on the subject of filing the income tax return, as code provides for a time-bound period for completion and maximization of value of the assets. The liquidator of the company in liquidation under the code is not required to file income tax return. Then there is no question of claiming refund of TDS deducted under the Income Tax Act. In conclusion, NCLAT held that the learned adjudicating authority has erroneously held that the deduction of tax at source does not mean raising demand for collection of tax by the department. It opined that TDS under section 194 of the IT Acts is an advance tax, capital gain tax recovered through transferee on priority with other creditors of the company, and because such recovery of due is inconsistent with the waterfall mechanism of the code. Therefore, by effect of section 238 of the code, the waterfall mechanism shall have an overriding effect over the provisions of the IT Act. The Honorable NCLAT set aside the NCLT order and has made direction to the IT department to refund the TDS deposited by the successful bidder to the liquidator.
Okay. I think a lot of cases have come regarding this, demands by the income tax department. But I think there is a subtle difference between these kind of claims by tax, the GST or commercial tax department, income tax department, as opposed to, the demands of EPFO, gratuity related things. The judiciary is very clear. The code is also very clear that income tax departments are just operational creditors. And in case they have not submitted a claim, then there is no question of considering any payment for them in CARP or in liquidation process. And in this particular case, it has been clearly highlighted that deduction of TDS is not actually a liability or assessment of a tax. It is only an advanced kind of a deduction. And later on, when the company undergoing liquidation is made to again claim this amount by filing a return, the same money has to be again distributed to the stakeholders. So once you distribute the net amount, and then you follow the process which takes God knows how many years, and then again you have to distribute to the same set of the stakeholders, there's no point in having that kind of a two-step approach. I think the court has taken a very clear view that this is the kind of a situation. Don't have to deduct and remit to the government. Okay. Sir, Raghu, can we move on to the next?
Sir, one anecdote to this for the benefit of all the participants. They can also anticipate when the sub-registrar has to register the property at that point of time, as it happened in 2 of our cases. What happened? The registrar says, no, you are supposed to give me the TDS that has been paid. That clearance certificate has to be brought in. Otherwise, you will have to bring the NOC from the income tax official. This is one of the demands by the SROs. The people here, the participants, may please note that by giving this, the judicial case laws points and saying that it has been already held in appropriate forums, that the TDS need not be deducted, by giving these orders, copies along with the document to be registered, then the registrars probably leave out that demand. Otherwise, they refuse to register the document, because in any other case of normal registration, they are always having this 1% paid and the paper added to the documentation. So this is one more point, maybe the participants can vote.
Yeah, thank you, Mr. Nageshwaran. I think the sub-registrar office, they look at purely from revenue angle to collect as much as stamp duty as possible. I think one more case law which we are going to discuss in our thing regarding stamp duty, there I think we are taking note of that point. Yes. And we move on to the next decision. Okay, so this is regarding a share pledge, company which is undergoing the IBC process. the RP rejecting their claim. I think Ms. Mekhala from our team, Mekhala ma'am is also an insolvency professional and ex-banker. She will be highlighting the points on this particular decision. This is a decision by the Supreme Court of India. Yeah, please go ahead, Mekhala ma'am.
Good afternoon, all. I welcome you all for the webinar. And today it is Vista ITCL India Limited versus Dinakaran Venkata Subramaniam and others. It's a Supreme Court of India. Date is 4/5/2023. The corporate debtor Amtech Auto Limited had pledged the shares of JMT Auto Limited with Vista ITCL Limited. In this case, Vista ITCL in India filed their claims with the corporate debtor because it was into CARP. But RP rejected the claim. They went for an appeal claiming the right on the basis of the pledged shares. See, actually, the CD had gone for CARP. So they submitted their claims in Form C, claiming that they are the secured creditors. However, the claim was rejected by the RP and which was not at all challenged by the Vista. After some time, the resolution plan came in and Liberty House Group Private Limited plan was approved by AAA. However, LG did not fulfill its commitment. So the AAA passed orders directing the COC and RP to go in for consideration of Decon Value Investors Plan, which was listed at the second. Meantime, Vista went for an appeal asking for claiming the rights on the basis of the pledged shares. The question here, the NCLAT observed that there was no money lent to the corporate debtor, as well as they don't owe any money to the Vista. The NCLAT dismissed the appeal, hence the appeal in Supreme Court. In Supreme Court, the question was whether they are the secured creditors. If they are the secured creditors, then are they coming under financial creditor or operational creditor? And that was the question dealt. Let me go to the case now. KKR India Financial Services Private Limited and L&T Finance Limited had extended financial assistance in the form of short-term loans of an aggregate principal amount of rupees 500 crores to WLD Investment Private Limited and Brasco. And the said loan was used by and for the benefit of the corporate debtor, that is Amtech Auto Limited. The CD had created a pledge agreement dated 5/7/2016 in favor of Vista over 16 crores 82 lakhs 6,100 equity shares of face value of rupees 2 each of JMT Auto Limited held by the corporate debtor. An application under Section 7 of the IBC was admitted against the corporate debtor Amtech Auto Limited on 24/7/2017, and on 2/11/2017, Vista filed its claim as a secured creditor of the corporate debtor and submitted Form C claiming a principal amount of rupees 500 crores. However, the claim by the appellants was rejected by the resolution professional in 2017, which was not challenged by Vista. The resolution plan submitted by the Liberty House Group Private Limited was approved by AAA by order dated 25/7/2018. However, Liberty House Group did not fulfill its commitment, and the AAA passed an order directing reconsideration of the COC for consideration of Decon Value Investors Plan. Thereafter, further proceedings were initiated by NCLAT, by the COC, etc. Thereafter, the appellants filed another application under Section 65 of IBC, claiming the rights on the basis of the pledged shares. The NCLAT dismissed the said appeal by observing that the appellant claim has been rejected by way back in the year 2017, and the decision in this regard has not been called in question, and therefore it is not open for the appellants to raise the same issue in 2020 by filing a lien. The NCLAT has also observed that the appellants have not lent any money to the corporate debtor, and the corporate debtor did not owe any financial debt to the appellants except the pledge of shares was to be executed. The NCLAT dismissed the appeal, hence the appeal in Supreme Court. Observations of Supreme Court. In Anuj Jain IRP of JP Infratech Limited versus Axis Bank Limited, the issue was whether the lenders of JP Associates Limited, that is JAL, the holding company of JP Infratech, JIL, the corporate debtor, hold the status of financial creditors of JIL within the meaning of 5 subsection 7 and 5 subsection 8 of the IBC. This issue had arisen as JIL had mortgaged certain land with the creditors of JAL. It was held that a person only having a security interest in the assets of the corporate debtor, even if falling in the description of secured creditor by virtue of collateral security extended by the corporate debtor, would nevertheless stand outside the set of the financial creditors and consecutively outside the COC as well. The aforesaid decision is also based upon the meaning assigned to the term financial debt under section 5, subsection 8 of the code. In view of the above, Vistra is a secured creditor to the extent of the shares pledged to it by the corporate debtor, that is Amtech. The expression security interest as defined in section 331 of the code states that it means right, title, interest, or claim to a property created in favor or provided for a secured creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, and encumbrance, or any other agreement for securing payment or performance of any obligation of any person. The person in whose favor the security interest is created need not be the creditor who avails the credit facility and can be a third person also. Security interest can be created for credit facilities, loan advance to other person. It is accepted and admitted that Vistra has security interest in the pledged shares. Vistra is to be treated as a secured creditor, but would not fall under the category of financial creditor or operational creditor. A very odd and a peculiar situation is created where a secured creditor is denied the benefit of the security interest. The right to exercise the sale of security interest, yet not to be treated as either a financial creditor or an operational creditor. If Vistra is to be treated as a financial creditor of the corporate debtor, to the extent of the estimated value of the pledged shares on the date of CIRP, the said solution may not be viable as the resolution plan has already been approved by the COC without Vistra being a member of the COC. Therefore, we would opt for the second option. The second option being under section 52. The other one is to treat Vistra as a secured creditor in terms of section 52 read with section 53 of the code. Vistra as a secured creditor who will be entitled to retain the security interest in the pledged shares and in terms thereof would be entitled to retain the security proceeds on the sale of the said pledged shares under section 52 of the code read with regulation 21A of the liquidation process regulations. Both the COC and RP wanted Vistra to be treated as a financial creditor of the corporate debtor, but they wanted the claim to be dismissed on the grounds of delay, laches, and acquiescence. Vistra had not objected to the resolution plan submitted by the erstwhile resolution applicant LHG, and since the resolution plan submitted by erstwhile resolution applicant did not in any way affect the rights of or interests of the Vistra as a secured creditor in respect of the pledged shares. Conclusion. Honorable Supreme Court concludes that in view of aforesaid findings, the impugned judgment of NCLAT affirming the view taken by the NCLT is partly modified in terms of our directions holding that Vistra would be treated as a secured creditor who would be entitled to all the rights and obligations as applicable to a secured creditor in terms of section 52 and 53 of the code, and in accordance with the pledge agreement dated 5/7/2016. Present appeal got disposed of in the terms without any further fuss. Okay. So this was the conclusion arrived by Supreme Court saying that yes, Vistra can be treated as a secured creditor in this particular case because one plan which has already been approved, but still they could not continue, and it's already another plan is pending for approval. So in the meantime, they can be treated as a secured creditor. They can come in and they can go for voting and for approval. That was the decision taken in this.
Okay. Thank you, Mekhala ma'am. One more case, on this related to the subject. Can you please go to the next one? This is on the waterfall mechanism under section 53 of IBC. Recently, there has been a decision on this matter by the Supreme Court, which is in the on 2nd May 2023, right, Raghu?
Yes.
This decision came. In this particular decision, which was earlier contested by the parties regarding this statutory claims of workmen dues, how they should be dealt with. And the reference we can take here on the decisions by NCLAT and Supreme Court in the Jet Airways matter. Having discussed and decided in the matter that the employees' dues and workmen dues are always paramount, in terms of the distribution, a decision on Moserberg Karamsari Union has also come on similar lines, perhaps, giving an impact on the Companies Act as well. Okay, so I think Meglama, would you like to elaborate on this?
Yes.
Okay, please go ahead.
So it's Moserberg Karamchari Union versus Union of India and others. A writ petition was filed and they sought for an appropriate direction so as to leave the statutory claims, that is the workmen dues, out of the purview of waterfall mechanism. See, they were citing the Companies Act 2013 and they wanted to come out of the claims from the workmen and employee. They discussed that if in companies they go for winding up, it is not in the case of IBC. In case of IBC, only sick units or people or the promoter where he is not in a position to pay the employees' dues and debts of the bank, they come for IBC. Whereas in case of winding up, it is not so. Even a sound company, a well-groomed company can also come out of the registration saying that they would want to come out. So in that case, you cannot compare the Companies Act winding up with the IBC cases. So they decided, and they also said that we can go for workmen dues are being placed in first priority after the CRP clause. The only reason is they need to be paid because then only the company can survive, and workmen dues are to be given first priority. So now let's go to the case. A writ petition under Article 32 of the Constitution of India, the petitioner, Moserberg Kamachi Union, have prayed for an appropriate writ, direction or order striking Section 327(7) of the Companies Act as arbitrary and violative of Article 21 of the Constitution of India. The petitioner has also sought for an appropriate direction so as to leave the statutory claims of the workmen dues out of the purview of waterfall mechanism. However, in view of the introduction of new regime under the IBC, in case of liquidation under the IBC, distribution is to be made as per Section 53 of the IBC. It is further prayed to issue an appropriate writ in the nature of mandamus by giving an purposive interpretation of Section 53 of IBC and pass necessary directions. The Companies Act 2013 does not deal with insolvency and bankruptcy when the companies are unable to pay their debts or aspects relating to the revival and rehabilitation of the companies and their winding up if revival and rehabilitation is not possible. In principle, it cannot be doubted that the case of revival or winding up of the company on the ground of insolvency and inability to pay debts are different from cases where the companies are wound up under Section 271 of Companies Act 2013. Under Section 271 of the Companies Act, even a running and financially sound company can also be wound up for the reasons in clauses A to E. So they both are not same and they are different. The petitioner cannot claim the same benefit in case of winding up and liquidation of the company under IBC. Section 326 of the Companies Act 2013 deals with overrating preferential payments which have to be paid in priority to all other debts. These include the workmen debts, dues of the secured creditor, where the secured creditor has realized the secured asset but could not realize the entire amount, or the amount of workmen's priority in a security payable under the law, whichever is less, with the workmen's dues. Thus, this balance and equates the rights of the secured creditor to realize the secured asset. But in case the secured creditor is not able to realize the full amount or has an amount to the workman if payable under the law, whichever is less, these dues rank pari passu with the workman's dues. A conscious decision has been taken by the Parliament legislation in its wisdom to keep out of all some dues to workmen, employee from the Provident Fund, Pension Fund, and Gratuity Fund from the liquidation estate assets. That is as per section 36(4), and that the workmen dues for the period of 24 months preceding the liquidation commencement date shall rank equally between the workmen's dues to the said extent and the dues to the secured creditor. Therefore, the same cannot be said to be arbitrary and violative of Article 21 of the Constitution of India as contended on behalf of the petitioner. As per the settled position of law, IBC is a complete code and the object and purpose of IBC is altogether different than that of the Act, that is Companies Act. The IBC is a new insolvency mechanism. Therefore, the provisions under the IBC cannot be compared with that of the earlier regime, namely Companies Act. The waterfall mechanism now prescribed in the code with reference to the workmen's dues is a well-considered and thought of decision. The waterfall mechanism and the hierarchy prescribed to the workmen's dues should be seen in the overall objective of the code, which is to explore whether the corporate debtor can be revived so that jobs are not lost, the use of economic asset is maximized, and there is an effective legal framework which enhances the viability of the credit in the hands of banks and financial institutions. Section 53 of the code begins with a non-obstacle clause and states that notwithstanding anything to the contrary contained in any law enacted by the Parliament or any state legislation for the time being in force, the proceeds from the sale of liquidation assets shall be distributed in the order of priority, which is stipulated within such period and such manner as may be specified. The consequence of subsection 1 of section 53 of the code is that it will override the rights of parties, including the secured creditors, when the said provision applies. Section 53 of the code is complete and comprehensive code which ensures collection of assets, then provides the manner in which the creditors are to be paid. Even the rights of the secured creditor falling under section 53 of the code to enforce, realize, settle, compromise, or deal with the secured assets as applicable to security interest are diluted and compromised. Section 53 of the code talks about the workman's dues for a period of 24 months preceding the liquidation commencement date. The liquidation commencement date, as defined in terms of subsection 17 of section 5 of the code, is much earlier in point of time and need not coincide with the date of winding up. This is in the interest of the workman. The waterfall mechanism is based on a structured mathematical formula, and the hierarchy is created in terms of payment of debts in order of priority with several qualifications. Striking down any one of the provisions of rearranging the hierarchy in the waterfall mechanism may lead to several strips and disrupt the working of the system. The code is based on the organic evaluation of law and is a product of extensive consultative process to meet the requirements of the code governing liquidation. It has introduced a comprehensive and time-bound framework to maximize the value of assets of all persons and balance the interest of this. It introduced a comprehensive and time-bound framework to maximize the value of assets of all persons and the balance the interest of the stakeholders. In a waterfall mechanism, after the cost of insolvency resolution process and liquidation, sundry creditors share the highest priority along with a defined period of
Secured creditors.
The unpaid dues of workmen are adequately and significantly protected in line with the objectives sought to be achieved by the code and in terms of the waterfall mechanism prescribed by section 53 of the code. In fact, secured creditors are taking significant haircut and workmen are being compensated on an equitable basis in a just and proper manner as per section 53 of the code. The code balances the rights of secured creditors who are financial institution in which general public has invested money and also ensures that the economic activity and revival of a viable company is not hindered because it has suffered or fallen into a financial cost. The code focuses on bringing additional gains to both the economy and the exchequer through efficiency enhancement and consequent greater value capture. In view of the above, and for the reasons stated, Section 7 of Section 327 of the Act 2013 provides that Section 326 and 327 of the Act shall not be applicable in the event of liquidation under the IBC, which has been necessitated in view of the enactment of IBC, and it applies with respect to the liquidation of a company under the IBC. The writ petitions lacks merits and the same deserves to be dismissed and are accordingly dismissed. However, in the facts of the circumstance of the case, there shall be no order as to cause.
Okay. I think that's a very a long kind of judgment, but in the process, I think the Supreme Court wanted to say that a company which is not going through the IBC process, please do not go by the Section 53 waterfall mechanism. Please ensure fair, proper treatment to the employees to pay their dues in full on priority. Mr. Amresh, you want to say something?
Yeah, so I just wanted to understand. So that was a good reading of the law judgment, but in essence, what happened? Was the workman's due kept outside the waterfall mechanism or not?
Sir, in this case, this Moser case, they go to say that even the Companies Act requires certain kind of tinkering with the mechanism so that they get the full dues. In IBC, you are very clear, that there is a provision under Section 53, some 12 months and 24 months are there. Okay, in the case of the liquidation process. So Moser, I think it went into liquidation, I think.
Yes, liquidation.
Okay. So finally, I think the paramount importance of workman dues has been reaffirmed by the Supreme Court. So the Supreme Court goes on to say that, yes, their dues are very important. Please take care of their dues. And I think it goes on to say that the Companies Act provisions were introduced much before the IBC came into picture. Okay. And the IBC process is mainly for inability to pay the debts. Insolvency process is mainly for inability to pay the financial liabilities. Whereas a company in the normal course also can opt for liquidation, right? Winding up. Under Companies Act, you say that it is a winding up process. And winding up can take place when the company is solvent. Do you agree with me, Mr. Amresh? A company can opt for winding up even when its financial health is good. It is having a sound financial footing. It has got assets. But still, it may say that I don't want to continue. I don't want to go on prolong the process. I would like to finish everything. So saying that they are in winding up, they cannot take the provisions of Section 53 and say that I will pay only on priority 12 months dues or 24 months dues. You may have to pay the entire dues. I think that is the crux of it. I think the law actually, has been evolving, particularly with reference to IBC matters also, regarding this PF and gratuity. But at the same time, IBC puts a very, kind of a differentiating color on the dues, workman dues and employee dues, where they don't consider this PF and gratuity. They go on a separate footing. Okay. So this is where the difference comes. In IBC, there is a kind of a limited 12 months and 24 months payable on priority. The remaining things come on the queue. They stand on the other debts and dues. Whereas in this Companies Act case, they say that they have to pay the amount in full. Okay. So, Mr. Amresh, if there is any further doubt on this, we can definitely.
So I think so. Sorry, but since this is a pretty long drawn case, again, not very clear. What I do understand is, as per the waterfall.
Sorry, sir, we are not able to hear you.
Can you hear me? Am I audible?
Voice is breaking.
Am I audible now?
Sir, Mr. Naresh,
you are
can
audible.
hear him? Can you hear Amresh?
Yeah. So what I'm saying is, as per Section 53, 12 and 24 months.
Naresh, sir, can you hear Mr. Amresh?
Yes, sir, I am able to hear him.
So 20 and 24 months are there, certainly as per the waterfall mechanism. But when we talk about statutory dues, I take them to mean, contributions to provident fund and gratuity and so on. Now, those are the funds which are anyway supposed to be outside of the liquidation estate. If there is any pendency in that, that is what probably the workmen would have been arguing about. So in some, the question which I'm still not very clear as from the judgment is, are those statute dues pertaining to provident fund, gratuity and whatever required to be paid and paid outside of the waterfall mechanism? Yes or no?
I think in my view, it should be yes.
Okay.
Outside of the 53 waterfall mechanism.
Okay.
Okay, thank you, Mr. Amresh, for your perspective. Moving on to the next case law on this subject. We are going to talk about two important cases. Of course, the audience might be aware of these two matters, but still, to highlight the importance and the kind of wordings and language used by Honorable Supreme Court regarding this withdrawal of, a Section 12A application in the liquidation process. So this is, on Vallal RCK versus Siva Industries and Holdings Limited. So this is a decision by the Supreme Court on 3rd of June 2022. And also quoting on this judgment, the NCLT Bangalore bench decided quickly in another matter within 3 days of the decision about the possibility and the doability of a Section 12A application by which the liquidation process can be set aside and the company can be back on track. We have our team member Anusha, who is a lawyer, and so she will be having a quick perusal of these two cases highlight. She will be doing it. Yes, Anusha.
Good afternoon, everyone. Today, I'm going to present the case and a brief introduction about Section 12A of IBC. Section 12A of IBC was inserted into the IBC Amendment Act by the way of IBC Amendment Act 2018, where the government constituted the Insolvency Law Committee for implementation and review of Insolvency and Bankruptcy Code. They suggested various suggestions, out of which one of the suggestions was inserting 12A, which was a smooth exit from the judicial proceedings. So, according to this act, any application filed under Section 7, 9, or Section 10 can be withdrawn after the commencement of liquidation or CIRP process if such proposal is approved by 90% of the voting share of commercial of creditors. I feel this is one strict provision as compared to Section 30, subsection 4 of the code, because withdrawal of application under Section 12A requires a minimum higher threshold of 90% voting share by the committee of creditors, as compared to Section 30, subsection 4 requires only 66% of approving the resolution plan.
Track. Yeah, go ahead.
So, Lokhandwala Kataria Construction Private Limited versus Mrs. Finance Investment Managers LLP. It was the first case where the withdrawal of application was admitted by Honorable Supreme Court under Article 142 of Constitution of India. So, let's move to Vallal RCK versus Shiva Industries and Holding Limited and others. A Section 7 application was filed against the corporate debtor, that is Shiva Industries and Holdings Limited, by the IBC Bank for initiation of CIRP in NCLT Chennai. Royal Partners Investment Fund Limited submitted one resolution plan, but it was not approved. It was not approved by the Committee of Creditors, and it only got 60.90% of votes, and it couldn't meet the minimum requirement of 66% of votes. So the plan did not approve. Meanwhile, the promoters of Shiva Industries and Holding Limited approached the RP for a settlement plan, and that initially the plan was admitted. The settlement plan was got approved by only 73%, but later on, International Asset Reconstruction Company Limited (IARCL), they voted for the settlement plan, and the settlement plan got 94.23%. Then the RP approached the NCLT Chennai for the withdrawal of section 7 application and admission of settlement plan, but it got rejected. The NCLT held that this was not a settlement plan, but it is a restructuring plan. So this cannot be withdrawn. Section 7 application. Then the promoters moved to NCLT against the agreed order of NCLT Chennai. There were main two considerations in this case: whether
the application,
whether the resolution plan, when it is not approved by the Committee of Creditors, and when it was pushed to liquidation, whether a settlement plan can come in and the settlement plan can be approved. And second question, whether the NCLT can doubt or judge the commercial wisdom of the Committee of Creditors. Both the applications were dismissed. The settlement plan was dismissed because they were not eligible under Section 29A. Then they moved to Supreme Court. The main question was whether adjudicating authority and appellate authority can judge the commercial wisdom. The court has been constantly giving importance to the commercial wisdom of the COC without any judicial intervention to ensure the smooth process. Then this case was approved. The settlement plan of the promoters were approved, stating that the commercial wisdom of COC cannot be questioned, and when the settlement plan was approved by more than 90%, the settlement plan can be approved even when the case is pushed into the liquidation stage. Based on this case, the NCLT Bangalore in Aradhya Wire and Ropes Private Limited versus South India Bank gave the same judgment that the NCLT and NCLAT does not have power to judge the commercial wisdom unless the decision of the COC is capricious, arbitrary, irrational, de-oris to the provisions of the statute of the rules.
Absolutely, yeah. I think, sir, in this case of Section 12A coming into play at the fag end of the resolution process, in fact, in the liquidation process, whether it is correct on the part of the COC to approve a 12A plan. This has been examined in detail by the Supreme Court. I think Supreme Court very clearly laid down that the judicial authorities have no role to play unless the decision of the adjudicating authority is capricious, that is without considering on merit any of the provisions. They have just on an arbitrary manner decided, this plan. The reason which has been given in the case of Siva Industries in the NCLT stage would be like this. If I go ahead with the liquidation and then it takes quite an amount of time, what am I going to get in the liquidation process? Instead, whatever these promoters are giving me now, it meets my recovery process, and also in terms of my net present value, this is far superior. So this is a decision I am taking. So the lenders have taken a call that let's not go ahead with the liquidation process for eternal timeline. Let's go ahead and then settle it. At least some value I will get. So that was a decision call taken by the lenders, the committee of creditors. But then the NCLT set it aside. NCLT said that, look, gentlemen, your commercial wisdom is for approval of a resolution plan. Your commercial wisdom is not for a Section 12A withdrawal process. I think that was a stand taken by the NCLT bench, and which of course was got endorsed by the NCLAT as well. But then Supreme Court struck it down. Supreme Court said that we don't have any business to interfere with the commercial wisdom of the lenders. Let them take their own call unless somebody proves that there is a foul play. There is some kind of a absolutely obviously some decision has been taken without application of mind. So that is the kind of these two cases are the aware. In fact, in our own case, one particular matter, a similar kind of a situation happened where the company did not have any asset, or it had got only one asset, which did not have enough kind of ability to pay the debts of the lenders, and it was in liquidation. Nobody was willing to come forward to take over the company. But finally, the promoter came forward and he settled the matter with the lenders. He closed the matter with the lenders, and the lender said that I don't have any further option to continue. I don't want to continue on this process. And he said, I'm okay with withdrawing my application. So in that case, we approached the NCLT Chennai, and NCLT Chennai passed an order stating that the company be relieved from the rigors of the liquidation process. Let it go back on its own feet and let it continue. If it is going to help the economy by way of reviving the company with some employment, some activity happening, what's wrong with that? So I think, sir, the audience, the members, learned members here may note the Section 12A, very briefly, it's only a one sentence, Section 12A. The adjudicating authority may allow the withdrawal of application under Section 7, 9, or 10 on an application made by the applicant with the approval of 90% voting share of the committee of creditors in such manner as may be specified. The only point I am seeing here is the committee of creditors. So one may take a view that COC is there in existence in CARP, but they are not in existence in the liquidation process. Maybe that analogy might be applied, but then now you can see in the liquidation process, the recent amendment says the same COC will migrate, will get into the liquidation process, and they form the stakeholders committee, isn't it? And later on, after the collation of claims received during the liquidation process, a formal stakeholders committee will be instituted. In which case, I feel that, the shareholders, generally the shareholders cannot make a claim during the CARP process, but they can make a claim in the liquidation process. So the blurring line between CARP and liquidation, insofar as Section 12A is concerned, I think it is slowly, disappearing. It's slowly disappearing. There is nothing wrong in approving a 12A, even when the company is in liquidation process. I think that is the kind of a view emerging now. Okay. So
sir, I have one small clarification out here. Suppose in a process, the company, the CD is in liquidation, and there is only one SCC member, that is bank. corporate debtor and the bank sat together and just tried to come out with some kind of a compromise or arrangement or some kind of OTS, but ultimately it didn't fructify. But the corporate debtor has some kind of operation running on.
Okay.
Whereas, like, bank is very reluctant in giving any kind of relief to the corporate debtor. They are, I mean, more prone to, like, sending the corporate debtor in liquidation. How would you look at it?
I think there were some kind of a disturbance in your audio, Mr. Rajkumar. Is it Mr. Rajkumar Mato?
Yes, yes, sir, you're right. I'm Rajkumar.
Okay.
Am I audible now?
You are participating from where, Mr. Rajkumar?
I'm participating from Pune.
Pune. Okay. We didn't get your one last sentence clearly, sir. What exactly is the question?
Actually, like, it happens, like, many a times, like, it is more than like, and grudge kind of thing. Grudge, like, you have some ego, like, even though the company is in operation, it has some kind of operation, but just due to, like, the some kind of consensus is not there between the corporate debtor,
Okay.
I mean the promoter and the bank. Like,
Okay.
bank being the sole financial creditor in that, bank decide to no, I nothing doing, I will send your company into liquidation.
Okay, good, sir. It's a good question. In reality, such kind of situations may be there. The best course open, is for the promoter. I think he is the person who wants to claim the company back from the IBC process. Am I right, sir?
Yes.
So it is in his interest either to secure 90% approval of the stakeholders committee, failing which, see, you can appreciate one thing. The committee of creditors during the CARP period is purely a financial creditor setup. It's a combination of only financial creditors during CARP process. Whereas when you go into the liquidation process, the stakeholders committee is actually consisting of operational creditors, even shareholders also. So to secure a 90% voting might be easier in the case of a liquidation process where the stakeholders committee is a broad-based one. And you are also saying that the corporate debtor is in an operational condition, it is a going concern. So all the more a good reason. In fact, Aradhya Vyas case, which was highlighted by Anusha, the employees would have filed an IA in that application stating that, sir, we are in this company for so long. We know the work and nothing else other than this work. So we can do a wire drawing, we can do a rope manufacturing, but we are not trained to do any other work. So please allow this company to come back on its heels. So please allow the company to restore itself. So that kind of an application would have been made by the Employees Association. Am I right, understand? So an example or case where you are saying it is best for the promoter to approach the NCLT to seek an intervention. Look, I'm running this company or the company is being run, but I want it back. Some of the creditors are not approving or they are not voting for it for whatever reasons they know. But Mr. Mato, if you said about the ego issue, right? Something like ego issue.
It happens, sir. I mean, it is like, it happens.
Yeah, true. So they may not like the company to go back into the hands of the promoters, possibly.
Yes.
So the best option for them would be to challenge it in the NCLT. I think that's the only way, sir.
Okay, sir. And
And also,
suppose,
yeah.
sir, there is no work in that, like, suppose there are 10, 15 employees. They can move an application intervention, I mean, IA.
Yes, very much. Yeah, very much they can.
So again, that commercial wisdom will come into picture, sir, while giving the judgment.
True. Yeah, there can be a case of a commercial wisdom. So probably, I think, the best part of the whole thing is that whether the company should be allowed to continue as a going concern or it should go into liquidation. If in the process of liquidation, the liquidator is going to sell the assets in piecemeal, if he is going to just, sell off the assets rather than selling it as a going concern, then the promoter has got a better stand. He has got a better chance, because he may say in the bench, he may say in the court that rather than selling the assets in piecemeal, I am here to take over the company as a going concern, by which, the whole process also will continue, employment will continue, economic, revenue generation capability will continue. That may have a slightly a stronger footing when the bench considers. No doubt commercial wisdom will come into play, but the court, the adjudicating authority, can always justify some of the reasons. Then if you know, Mr. Rajkumar, in some cases where the plan has been approved by the COC, NCLT has rejected the plan. Am I right, Ila? Am I right,
Yes, sir.
Nageshwaran sir? Huh?
Yeah,
Yes, sir, we have.
So, so the commercial wisdom is not exactly a kind of, unquestionable, paramount, supreme kind of a right. There can be certain intervention by the adjudicating authority, but not for the sake of it, where they find a genuine, a valid, a compelling reason to interfere. I think adjudicating authority any day, they can do that.
Yes.
So good, sir. Good. Thank you, Mr. Mathur, for
Thank you so much for elaboration.
thank you, sir. Thank you. Now moving on to the next item. Do you have something?
Yes, sir.
Okay, okay. So we are going to talk about a few more cases. Yeah.
Yes.
This is on
Stamp duty.
stamp duty application on the liquidator when he sells the assets and gives the same certificate to the successful bidder. So we have our team member, Ms. Ilamati, who is company secretary and advocate, and she has been successfully handling a lot of cases for our team. Yes, Ila, you can proceed.
Very good afternoon to everyone. Today I'll be presenting a few cases which are essential in the liquidation process. Firstly, let's go into the details of this order passed by the High Court of Telangana in the matter of Anirudh Agro Farms versus the state of Telangana. So this is a case where the liquidator would have given an e-auction immediately when the liquidation order was passed. And in the e-auction, the company was successful to get a very good bidder for the property which was auctioned. Accordingly, the bidder also had deposited the entire, the bid amount to the liquidator. So upon receiving the money, the liquidator goes ahead and gives a sale certificate. So the sale certificate is for the auctioned property with all the details. He has given it to the successful bidder. So then the bidder goes to the sub-registration office to get the property registered in their name. So at this juncture, what the liquidator does is he, gets into his job of intimating other people about the auction, and he gives a letter to the sub-registrar that yes, this particular property is, transferred to this particular successful bidder in this liquidation process. But the sub-registrar, once he received the letter from the liquidator, he says, no, I will not take on record the sale certificate because sufficient stamp duty is not paid. So if we see the Stamp Act or the Registration Act, there is a mandate that when a property is being conveyed to another person, the concept of stamp duty comes in. So this stamp duty is supposed to be paid to the government based on the market value of the property whichever is being conveyed. So in this particular case, this being a transfer of property under the liquidation process, no stamp duty would have been paid by the buyer or the liquidator. It wouldn't have been factored in the cost as well. So the registrar gives a letter to the liquidator saying, no, I will not take on record the sale certificate because you didn't pay the stamp duty. The registrar relies on Article 47A of the Stamp Act. This particular section says that when a property is being registered below the market value, then the registrar cannot directly take it on record. He will have to give it to the collector of the district. So the registrar is refusing to take it on record. Now what the liquidator does is he goes to the High Court. So the auction bidder will file the application. The successful bidder goes to the single judge bench of Telangana High Court, and they are saying that the single judge will hold that yes, stamp duty is a mandate. You will have to pay it as per the Indian Stamp Act. So the single judge bench dismisses the application, saying that it is a mandatory requirement under the Stamp Act to get it done. So the successful bidder files an appeal before the division bench in the same High Court of Telangana. So the division bench, what they do is they go through the provisions of IBC as well as Section 89 of Registration Act, 51 of Registration Act, and 47 of Stamp Act. Section 89 of Registration Act says that the registrar has the power to take on record, that is to get certain copies of conveyance and put it in the books of the registrar. This is known as taking on record for the registrar. So the division bench of the High Court are saying that sale certificate is not the document or the instrument which is conveying the property. It is just to be taken in the books of the registrar. Hence, there is no conveyance as such, and so there is no requirement of the payment of stamp duty. The High Court of Telangana, while dealing with this matter, they rely on two other judgments which were analyzed well by the High Court as well as the Supreme Court. One is Sri Varalakshmi Charitable Trust versus Sub-Registrar, and the Supreme Court had passed a similar judgment in a SLP petition in the matter of Inspector General of Registration versus Madhurambar. In both these judgments, the Supreme Court and the High Court earlier would have observed that the Registration Act deals with the books which are to be kept by the registrar, and a sale certificate which is issued by a liquidator under the liquidation process auction is not necessarily an instrument through which the property is conveyed. Hence, the registrar has all powers to get the sale certificate on the record and put it in his books, which is maintained in his office. So the High Court would have finally allowed the application filed by the successful bidder and would have said that stamp duty is not applicable since it is not a proper conveyance of property. It is just a sale certificate which is to be taken on record. So this particular judgment would be very much reliable in the auction, in the liquidation process, because it being the first step of selling the properties of the liquidation estate. I think this is an essential judgment which we can take it on record and proceed further when any property is being registered.
And madam, what about movable property?
Sorry, sir. Can you just repeat your question?
Yeah. What about movable property?
Sir, movable properties, I think stamp duty requirement is only on an immovable property as per the Stamp Act as well as the Registration Act. So your question is towards the facts of
Suppose I have, yes, suppose I have a combination of assets in the liquidation estate, which is under process of selling my both the assets. So one thing is that so far as my fixed assets are concerned, the land and building, so on that stamp duty would get attracted automatically, right? So and what about the plant and machinery, furniture and fixture? If I sell it, will that stamp duty attract on that or no?
No, sir. For planting machinery and the other fixtures, GST will be applicable. That the purchaser will anyway take it back when they are filing the return.
Input credit. Okay.
Hello.
Yeah. Yes, sir. That means so far as movable property is concerned, only the GST portion will be applicable.
Yes, sir. Yes, sir.
Okay.
So yes, sir. I hope your query was clarified by Raghu sir now.
Thank you very much.
Yes, sir. Thank you. So moving ahead with a few other judgments. So with me, I have. Yes, anybody wanted to raise any question? Okay, so I'm continuing with the next case. This is a case determined by the Supreme Court of India on Jindal Steel and Power. So this case deals with the constitutional validity of regulation 2B under the liquidation process, read along with section 29A of IBC. So what happens in this case is the applicant, that is the appellant in this matter, is Mr. Arun Kumar Jagatramka. He is a person who proposed a scheme under 230 for the corporate debtor. So he is also a personal guarantor for the company. So this particular writ petition along with few civil appeals were filed, assigning that the notification issued by IBBI to introduce regulation 2B and the subsequent amendment which was notified by the amendment regulation in January 2020, through which IBBI tried to impose a particular condition under regulation 2B that a person who is proposing a scheme should be eligible under the code to give to take over the corporate debtor, which is nothing but section 29A. So by this writ petitions, the appellants are trying to contest that this particular amendment of IBBI is in violation of Article 14, 19 and 21 of the Constitution. So they're trying to basically say that imposing a restriction on who can submit a scheme and who cannot submit a scheme is not providing any equality, or is not in right with the spirit of the Constitution. So the issue before the Supreme Court was twofold. The first one is whether in a liquidation process under IBC, the scheme of compromise arrangement can be made under 230, 232 of Companies Act or not. The second issue was whether if it is permissible for a promoter to submit a compromise arrangement scheme when he is ineligible under section 29A. So on a literal interpretation of section 230 of Companies Act, it will suggest that there is no ineligibility as such which prescribed to submit a scheme for amalgamation or compromise arrangement. Whereas 2B of the IBC liquidation process before the amendment did not specify any ineligibility. Only through an amendment in January 2020, IBBI is introducing this clause of ineligibility. So what we will have to essentially see is that under 230, the NCLT's role is very limited. They get a scheme, they propose a meeting of the creditors or members or class as may be applicable. And once their voting share is 3/4 as per the Companies Act, they get to approve the scheme. Whereas it's not the same under the liquidation process. So in this particular case, the Supreme Court would have analyzed the importance of a company which is with the distressed asset, and it would have relied on Swiss ribbons and SR Steel to understand the spirit of IBC liquidation, and the court would have stated that 29A is a broader, it's a very broad provision to determine who is capable, who is eligible to take care of a corporate debtor. Just because a company is under liquidation, this particular restriction should not be waived off. In the best interest of the spirit of IBC, Supreme Court would have understood the interplay of Companies Act and IBC, and it would have said that yes, 29A is very much required for a person to submit a scheme under 230 of Companies Act under the liquidation process. So they would have said that 29A is very much applicable in the liquidation process as well. So it was the only underlying thing which a liquidator will have to see is whether the company is an MSME or not, and to determine who can submit a resolution plan or not. The same people will be still eligible to give a scheme of compromise arrangement under the liquidation process as well. This particular judgment marks landmark to rely on 230 judgments because it was passed in the month of March in 2021 itself. So the validity of regulation 2B read along with the amendment in January 2020 was upheld by the Supreme Court.
Okay, so I'm moving to the next case law. Okay, so this one I have just construed to just rely on one corporate debtor, which was handled by Chennai NCLT bench, which gives a very good practical aspect of the interplay between IBC provisions under liquidation and 230 of Companies Act. The corporate debtor is named Thiru Arur and Sugars Limited. So this under this corporate debtor, the liquidator would have received a scheme from Carl's Distillers to take over the corporate debtor, and the liquidator would have approached NCLT to get the scheme approved under Regulation 2B of IBC. The NCLT would have faced various stages of 230 under pure IBC pure Companies Act matter, and the status of a company under the Companies Act, under the IBC. So this NCLT in this particular matter, they would have combined both the provisions of 230 and Regulation 2B by stating that like how a sector or class of creditors or members consider a scheme under 230. In case of an IBC matter, the stakeholders have all the right to consider a scheme. So in this particular case, NCLT would have directed the liquidator to convene a stakeholders meeting. So in this particular stakeholders meeting, the practical aspect, the liquidator would have convened the SEC meeting for each class. For example, one meeting for FCs, then OCs, similarly classes of OCs. And he would have given a voting share who approved the schemes to the NCLT. So NCLT, while going through the voting percentage, would have said that, yes, the scheme is more than 75% under the Companies Act. But since the company is under liquidation under IBC, the courts would have interpreted it with voting percentage of 66 under IBC. So under IBC, for a resolution plan to get through, the minimum voting per share approval required is 66%. So NCLT, while approving the scheme, would have taken 66% as a muster rule to clear the scheme and not the pure Companies Act 75%. Further, in this particular case, the NCLT would have received objections from one farmer and the GST department and few other operational creditors whose voting share would not be even 10% on the board. But NCLT, taking cognizance of the fact that their voting percentage to object a scheme is not in line with Companies Act, NCLT would have encouraged their objections. NCLT heard them in detail. Since they had an remark that since the present scheme is not purely under 230s of Companies Act, it is read along with the IBC provisions. Hence, they would have heard the objections, though they are less than 10%. And the NCLT was of the opinion that the objections can be waived off by the scheme proponent, and they gave favorable orders for the scheme proponent to implement the scheme and take over the corporate debtor. So this is a good practical aspect of how to convene a meeting and how to get a favorable voting percentage, how the liquidator will have to go through the entire process of 230 under IBC. So this is maybe a good practical example for that. So moving ahead.
You have one more case.
So
Yeah.
Done. Okay.
It's a different subject, so we can just add on 230.
You want that?
This is a different subject.
Okay.
So if you want, you can add something on 230.
Okay. Under section 230 now, I see a few cases coming up. NCLTs are taking a kind of a positive view on scheme offered by not necessarily the creditors or shareholders. The pure Companies Act section 230 would say a member or a creditor can propose.
Right.
But an amendment to this provisions under 230 will also add that a liquidator also can present a scheme before the adjudicating authority. Recently, there was a decision by NCLT Chennai on Schollinger Textiles Limited, where a scheme, in fact, the scheme was proposed way back in 2020, sometime around in July 2020, got approved recently in the month of March 23, wherein a scheme proponent has brought the amount and successfully the company has been handed over. The asset has been handed over to them as a going concern, and we are associated in a manner, as far as the implementation of that Section 230 order is concerned. So that's again a good example how the NCLTs are viewing proposals schemes under Section 230. A few proposals, few applications are still pending in NCLT. Sometimes, we are just wondering how the bench is asking different types of questions. For example, a scheme is proposed by one of the directors of the company, S12 promoters of the company, jointly with another kind of a sponsor. They call, as a sponsor who gives me some additional financial resources. So the NCLT was asking, you prove the financial worth of the sponsor. Let the sponsor come and say that I have this money readily available, which is contemplated in the scheme. So even then, I think the matters are taking a little longer because, there has been a little bit of confusion as to how this 230 acts under an IBC process, a liquidation company. Okay, that's the kind of fact sheet on Section 230 under IBC. We have one more case left.
Yes, sir. Yes, ma'am.
Yeah, Ila, would you like to continue?
Yes, sir.
Yeah.
So the next case, which is similar to the concept we heard earlier, that is the role of the liquidator when he is receiving a scheme under 230, was dealt with by NCLAT New Delhi in Ramesh Kumar Chaudhary versus Anju Agarwal. This is in the matter of Sri Bhavani Paper Mills Limited. So in this matter, what would have happened is the NCLAT would have given pointed out directions to the liquidator on what steps are to be taken immediately when a scheme is received. So in this matter, actually the liquidator would have issued a e-auction notice to sell the assets, and subsequently would have received a scheme of arrangement under 230 from a shareholder of the corporate debtor itself. And the liquidator would have sent a reply to the scheme proponent saying that they are ineligible to propose a scheme under Section 29A. Subsequently, the liquidator's opinion would have changed due to change in few facts and circumstances, and the liquidator would have sent another letter saying that they are eligible to give a scheme, pursuant to which the proponent would have sent a revised scheme to the liquidator. So what this liquidator does is he would have received the scheme and placed it before the SEC members, stakeholders committee members. But the stakeholders committee members would have voted on the scheme earlier, and the voting percentage in favor would be less than 66 or even 75 under the Companies Act. So the scheme wouldn't have gone through. Later on, the person who proposed the scheme would have gone to the tribunal saying that the scheme is supposed to be considered. So NCLT and NCLAT, while dealing with this matter, they would have jotted down points to say that the 230 under Companies Act shouldn't be rigorously, directly implemented. It should be read along with regulation 2B of the liquidation process regulations. So the NCLAT in this matter would have in fact suggested that a person who is proposing a scheme is better to approach the secured creditors earlier, get their approvals in return, and then place the scheme to the liquidator along with the approval of the secured creditor. This requirement is mandated by 230 of Companies Act, where it says that 75% of the secured creditors would have to approve the scheme before the proponent goes to NCLT. So NCLAT would have stated that the scheme proponent is free to approach the creditors even before going to the liquidator, get their approval, and then go to the liquidator with the scheme. And then NCLAT would have also clarified that while conducting a meeting to approve the scheme, the liquidator will have to consider the voting percentage of the creditors who are present and voting at the meeting rather than taking the voting percentage as per their claim. And NCLAT would have also clarified that SEC is not the competent forum to determine whether a scheme is to be submitted to NCLT or not. They would say that a scheme, once a liquidator receives, should be given to NCLT, and later on NCLT will direct a SEC meeting, and then the validity or the essence of the scheme can be considered. In this case, right away SEC would have rejected the scheme, and it wouldn't have gone till NCLT itself. So NCLAT clarified that SEC is not the right forum to reject the scheme in a premature stage. So when a scheme is received, it is advised by NCLAT in this matter that it should be submitted to NCLT for their approval. So this is one such case. Post this case, only the Tiruvaruran matter was determined by NCLT Chennai bench to say that SEC members do have a hold on the scheme and to vote on it.
Absolutely.
So this is just, I think we have covered a very few case laws which have relevance in the day-to-day process of liquidation.
Thank you.
So over to you.
So this means, sir, this means that any compromise or arrangement kind of proposal has to be approved by during the CIRP. Is it so?
No, sir. No, sir. No. During the CIRP, you have a very well laid out resolution process, right? There is a resolution plan process, expression of interest has to come, and RFRP has to be issued, and then you have very elaborate kind of a process for getting a resolution plan. So there, even if somebody wants to submit a scheme, it has to be in the form of a resolution plan. So he has to be eligible under section 29A, and he has to submit expression of interest. All those parameters would have been would be required. So that's how it's done.
So now,
Yeah.
CRP, the end of the CRP will be whether the committee of creditors
Okay.
would like to go in for the compromise during the liquidation.
Yeah.
That has to be decided during the CRP.
Yeah, I think all the more, the kind of amendments coming or the thought process coming in the liquidation process, the decisions are being pushed to the COC. Even during the CARP itself, you take a call whether, in the liquidation process, a scheme would have been available or it can be considered. Those decisions also the COC is come to required to make now. I think not only that, Raghu, even who will make contribution to the liquidation expenses,
Yes.
that also has to be decided.
Yes.
And also the scheme. And another thing is whether as a sale, as a going concern, an attempt should be made by the liquidator, or he should go in sale of assets in a parcels. No, those kind of decisions are all required to be taken,
Yes.
even if the COC is having a plan before them. The idea is that if the resolution plan gets approved by the COC, it doesn't end there. Another hurdle is there. The adjudicating authority also has to approve it. In the event the adjudicating authority, shows a red flag, sorry, this plan, I'm not going to approve, then in which case the company gets into liquidation. So during that time, all those decisions of the COC, what I should do, what the company should do, what the liquidator should do, all those things would have been already decided by the COC, and they would have passed some resolutions. At least, it would be in place at that point of time. So this is how it happens. But in reality, if you ask me, I have faced a situation where the COC members asking me, why do you want me to take a decision on liquidation? When there is a plan, I'm going to approve the plan. But still, I think we cannot force the creditors to, make a voting decision. So in some cases, they don't vote, the resolution gets rejected. We just record that this is the resolution I had put forward and this has been rejected. That's how it goes. So, ladies and gentlemen, we have now come to the end of.
So, sir, my doubt is still not clear. Maybe my way of putting the question wouldn't be. My question was suppose during the CIRP, resolution is there during the CIRP, but as per the section, the COC has to recommend for the section 230. Suppose there is no reference made at the time of coming from the CIRP to liquidation stage. So as per the last two decision, I mean, the decision discussed by one of your colleague that SEC cannot take any call.
That is
Then-
section 230 you are saying, no?
Yes.
Sir, essentially now, the COC is now going to be the stakeholders committee, right? With the recent amendment, the COC will be in place at least for some time till the SEC is formed, the revised SEC is formed. Okay, during that time itself, a decision on the scheme has to be taken. The COC can take the decision. Okay, I understood your question like this.
Yes, yes. That means you mean to say that in the first, I mean, SEC meeting itself, like, the decision has to be taken by the COC in order to validate the 230 is, I mean, any plan, proposed plan.
Correct. Absolutely, sir. Absolutely.
Sir, I am Gopal Krishna. I'm calling from Hyderabad.
Yes.
I have a question. Now, as I understand, the COC, what is COC in a CIRP? The same as the SEC is akin to that as far as liquidation is concerned. Is that right, sir?
Yes, sir. I think within 7 days of the liquidation order, the same COC team will become stakeholders committee.
Yes. Then the second question is, sir, now there are two ways a case can come for liquidation, either through CIRP or directly. Now, if it comes to CIRP, then the COC becomes default SEC. If it comes directly, then what happens, sir?
Sir, how a company can directly go into liquidation? Only when the COC takes a decision to go for liquidation, right? There is a COC. Can
Through
you
an arrangement, can't it be done, sir? Compromise arrangement or through a voluntary winding up?
No. I don't think your question is correct. We are talking about a company which has entered the IBC process. If you are talking about a company which has not entered into the IBC process, that is different.
Yes, I am talking of not entering IBC process.
Okay, then we are not into IBC. At any point of time, any scheme can be given. And it is for the creditors to take a call under section 230.
Okay.
Right, Mr. Gopal?
Okay, sir. Yes.
Yes, sir.
Thanks.
That means, sir, in the first, meeting, post CIRP, and when it comes into liquidation process, then combination of SEC would be the past member of the COC plus that whatever claim or received during that liquidation process.
Okay.
So the section 233, section 230 mandate would be passed by a combination of a different class of stakeholders.
Correct.
Then
What is really happening is that the COC plus the additional creditors, plus the operational creditors, plus even the shareholders will become the new stakeholders committee, which will then be entitled to put forward a scheme which will be approved by the SEC. So the SEC, which was there initially
with 75% vote.
I'm sorry?
With 75% voting share under section 230, the requirement is 75%.
75% of combination of a different class of stakeholders.
Yes, exactly. I think that is where, in the case of Thiru Aruran Sugars, the NCLT would have taken a lenient view or a pragmatic view that when for a resolution plan only 66% is required, why do you want 75%? So since the very purpose of the scheme is to help large number of cane growers, the cane growers might be almost in thousands of numbers, they would be suffering there. So taking their interest into consideration, they would have approved the scheme, even if it has not got 75%. So this law actually, sir, it's very nebulous between IBC and Companies Act. How exactly, the percentage has to be calculated, whether SEC is the right forum or SEC is separate, creditors are separate. Should we take that kind of a view? And another thing, all of you will agree with me, SEC has got only advisory role. They can advise the liquidator on all these matters. The liquidator is not bound to accept, but at the same time, he has got accountability, right? He has to say why he is not going by the decision of the stakeholders committee. I think because of these issues, the number of 230 cases are not that great, but some of the schemes which find mention between the liquidator and the adjudicating authority, they are also locked into these kinds of issues. They are not seeing the light of the day. Every case comes, it takes a lot of time. Notice has to be given. The bench, the bench is sometimes confused between a Companies Act pure Section 230 case or an IBC company going through Section 230. Mr. Nageshwaran, I think you would have seen many a case like this.
Mr. Rajenderan, this is just an observation from my side. Has this whole thing not become more convoluted and circuitous?
Yes.
Because
yes, Mr.
what was
Amrish,
initially an advisory role has become an executive role. From CRP, you're going to liquidation, and you're again going back to not even CRP, going back to Companies Act. I think the whole thing appears to become far more complex and circuitous.
Complex. Absolutely, you are right. It is simply, the things are getting complicated, I can say. So maybe, sir, I think, the law is taking, definitely a good time for evolving, and then, with little more clarity, things will emerge. Maybe in the next few years. I think IBB is taking a lot of proactive steps, particularly in this matter of Section 230 related cases. Some amendments I think might be on the cards in the next round of amendments being planned. Sir, Mr. Nageshwaran, are you there, sir? Or some?
I'm here, sir. I'm here.
Oh, okay. Sir, I request you to take a few questions from some of the participants on these matters. Sir, any other question on this topic?
Yes, sir. Anyway, liquidator has a right to take a decision taken at the SEC meeting. But sir, voting percentage is there. One has to respect the voting percentage and decision. Then after, followed by liquidator giving his comments or whether he is agreeing to stakeholders' decision or not.
Yes, Mr. Rajkumar, your views are right. That's what even at the beginning we were all discussing. This 230 section being brought in here and being imported without any changes from the normal Companies Act model for a 230 implementation under IBC. As Mr. Amrish Sood also told, it has got a lot of little bit of confusions created. In between, all of us were talking about the recent one where COC, as it is, becomes within 7 days, it becomes the first part of the SEC. Thereafter, after the claims are admitted and the liquidator is able to expand the SEC, then thereafter also, when the SEC is going to be expanded, every time we will have to go to NCLT and get their approval. Only after their approval, you can actually expand the SEC also. Till then, you can admit them, but they cannot be voting on the matters. In fact, it has really become totally in a mess at some point of time. In fact, in 2 of our cases, one of the biggest financial creditor who submitted the claim late, and he first in the NCLT process and the thing during that time he did not submit at all. Later on he submitted, but he submitted late. So initially he was not in the SEC. Now, later on he was brought into the SEC with the permission of the court. Now all those in NCLT, CARP have got a thing, all the COC's decision, any member who is joining subsequently is bound by the COC's decision in which he joined later. But in SEC, whether there is a position like that, we are not aware. Because 230 section of Companies Act is not talking about it. So in fact, to a greater extent, all these confusions are still to be sorted out. Probably, as Mr. Rajenderan told, we are waiting for a lot of things to happen. In fact, Mr. Raghu in between told there were suggestions in 21 and 22, 21, I think, that IBPA is going to take up a lot of matters with regard to liquidation process part of it. They brought out only the amendment. Even in that amendment, regulation amendment, a lot of things are still yet to be sorted out. We will wait for that.
So just another observation, we were told yesterday that the law committee which went into the amendment had very clearly brought about the discrepancies between 230 and the IBC process. And it was after that the regulations were amended.
Yeah.
So that is even more confusing, that the IBPI, when it was bringing out the amendments, did not take cognizance of the law committee observations.
Yes, that is also there.
It's very surprising because it's like IBC having been turned on its head. Regulatory change has made all the confusion, and you now also have the decisions of the NCLAT and even of the Supreme Court, as we just heard. So I think it's a very confusing thing. I don't know who's going to take action on this. Maybe Supreme Court has to do something. I don't know.
Yeah, this is true. In the liquidation, most of the time, this type of matters, even though earlier I told that this is giving us a lot of opportunity for liquidators to really make your own matters in such a way that you find a resolution. A resolution into the entire matter is what we are looking around. Yeah, somebody was talking. Yeah, Raghu?
Yes, sir.
Yeah, we can take the question answers now.
Yes, sir. Yes, sir. The case laws have been completed. We can take the question answers.
Yes, sir. We will jointly, anybody can address the question. We will jointly understand what is it about and try to find an answer for that.
Sir, any of the panel member, like, could just give us a broad line or the procedure, like, how to initiate section 230 and at what stage?
Yeah, I think earlier you were talking about this particular matter. Sir, actually you are right. 230, many of the time it is being told that the last COC, which is voting for the resolution plan, at that time itself, they should talk about this, is given in the regulations. But as Mr. Rajenderan explained, many of the time COC members, they say that they do not understand seriously why this sort of a thing. They say that you put the resolutions, whatever you want, we will just say we are abstaining or we will negate, and you record it. Your job is done. You please close the matter and go ahead with the resolution plan approval matter, which we also have been doing it. And many of the times courts also have not been insisting whether these things have been completed in that procedure when we are applying for the resolution plan approval, when we are sending it across, even though this part of the document is also attached, many a time it is not being looked into. Yes, very rarely it comes into the situation where, if at all, if COC plan is not approved, and then the regular, as per section 30, when they are not approving the thing 31, 33 is being brought in, and the liquidation is being put in by the AA, adjudicating authority. Thereafter, it comes into the matter. Now, exactly the first meeting of the SEC, which is presently going to be consisting of all the COC members, they can bring it at that point of time. Okay, we will go for a 230. Now, many times this 230 is also another drag on, because the timelines are very confusing, because they say within 30 days you will have to give the talking about the 230, you will have to give the advertisement, all those things. Whereas by the time when we are really completing the verification of claim and finalizing the claim, in addition to that, the SEC broad basing the SEC also will have to take place with the permission of the adjudicating authority, then every timeline is busted. In fact, in one of our cases, we have got to section 230 application was filed sometime in March 22. Till date, we are still going on because as again, Mr. Rajenderan told, sometimes the judiciary got confused whether it is a 230 as per IBC or as per Companies Act. Then in between, we call that first motion, second motion matters. Technically, in 230, as per the Companies Act part of it, the creditors will have to move the matters, and then they will be, the compromise, the people, proponent of the scheme should move the matters. The creditors will discuss, take a view on that, then it is being put on to the adjudicating authority for their stamp, for the subsequent meeting for the creditors. That is how it goes on 234 and 230 subsection 4 and 230 subsection 6. Whereas in SEC here in IBC, it becomes a confusion, whether it has to be routed through or not. But originally we were all under the impression, even today, at least I am of the impression, there is nothing in IBC anywhere it is stated that the 230 proponent of the scheme should go through the SEC. Earlier, in one of the cases where it was told that SEC, I was waiting for the SEC's clearance, that liquidator was pulled up by the court. Then why did you go to SEC? SEC has got nothing to do with your compromise proponent plan, and you need not have to go to SEC at all. There is one order like that, where he was pulled up and told that you were unnecessarily, you wasted the time. Now, most of the
So, sir, that means like whether I should put an agenda item for this in the first SEC meeting?
Yes, that is the thing. It is better discuss with the COC members, ex-COC members who are the first SEC member, discuss with them and put it as one of the agenda item and thing. Even if they are not suggesting, put it there and let them say it is. We are not suggesting that. At least you.
At least
Sir,
you will be safeguarded from the adjudicating authority or not pulled up.
That is the thing. Okay, so 230 proponent, whether they should be having the stamp of SEC or not is still an open question. But most of the time now, NCLT is asking, please have the, put it before the SEC and then take a resolution from there and put it to us. Then even the first motion itself, they are saying that you get it cleared by us. Whereas already most of the time, the creditors have approved the proponent scheme. That is why if you find even through or on in one or two other cases also, or most of the time presently, the first motion matter is given a go by, and straight away the court goes for the second motion where they appoint a chairperson and the matters are taken and the proponent schemes are being considered and voted on. This is the model most of the time nowadays is being followed in 230 IBC through 230 section through IBC. This is what is the model going on now.
So adding to that, the new amendment made in 16th September 2022, when the COC decides to go for a liquidation instead of resolution plan, in that case, during the approval, before approval of the liquidation itself, the COC can consider the 230, the compromise scheme.
Yes.
And after once the liquidation is ordered, they'll have to conduct the first COC meeting within the SEC meeting with the COC members within 7 days and file the compromise within 30 days. That has been, the amendment has been proposed with effect from September 2022. So that way we can also continue to work on the compromise and arrangement before the liquidation order is passed in case COC decides to go for a liquidation.
Yeah, this is even if the, as you rightly said, Raghu, in the last meeting of the COC, if they decide that they are putting the company into liquidation, from that time onwards itself, they can start working towards the liquidation.
Yes, sir.
Also, there even before the approval of the NCLT is taken for the liquidation. That is another thing to beat the timeline schedules not being extended. IBBA had suggested this, but of course, this is yet to be really brought into by way of any amendment anywhere.
No, sir, it is already brought in by way of amendment.
No, okay, it is by the regulation.
Yes, sir. Yes, sir. It is
But-
there in the CRP regulations itself. The
Yes.
amendments have been made effective.
Yeah, in the regulation it has been brought in, but most of the time, some of the courts always say regulation is, is only added to the thing, and it is only wherever it is exceeding the brief, then they take that it is our right, we will decide it this way. Unless otherwise it is told in the act, they are not really taking it up. These are all left to the judiciary now. Yes, sir.
Yes,
Any,
sir.
any other question? Yeah. I think Raghu?
Yes, sir.
Any other idea that we need to discuss with them? Anything left out during our timing? We can close it otherwise.
No, sir, there's no question. If he can ask that with regard to the amended 31A, the stakeholder consultative committee being widened with participants of all creditors. Now the stakeholder committee should be formed with all the creditors. Getting the 66% or 75% of the voting will be very tough, and the constitution itself will become very complicated. We would like to hear from the participants whether they have experienced anything on that.
Yeah, any of the seniors, definitely yes. Okay, maybe any of the participant, if they want to put in their thing by way of mail, maybe to ICSI, to the convener of this program, you can put it across anything on this liquidation part of it, where what has been considered presently by the judiciary and what are the things which are likely to better help in the futuristic matters. Maybe ICSI will be inviting them to give across their comments on that. With that, we can take closure of this matter, Raghu.
Yes, sir.
Please share the PPT.
Yeah, this PPT, we will give it across to ICSI. Then I
Yes.
think ICSI will give it across to all the participants or to their members. Yes, we will hand it over to them, sir.
Yes, sir, it will be better, like, we will study that all those, judgments
Yes.
first, then, we will be in a better position to, put across questions if any to.
Sure. That way, yes, within every judgment, there are certain other judgments which should have been covered, which you can get into that. There are, for example, that Aradhya Vyas is supposed to be a very simple judgment, but inside they have also talked about the Shweta Vishwanath versus Sharke, others, where it was a NCLAT judgment. Again, they have also talked about Navneeta Krishnan versus TBI, Central Bank of India. That also they have covered in that. And then, as we all know now, Vallala RCK versus Shiva Industries. All those three decisions, everything have been covered in the Aradhya Vyas before finalizing the matters. Like that, in every judgment, you have got inside, there are certain of the areas where they have covered. And the judgments, particularly on liquidation, the judgments every judgment, when you go through that, gives you a lot of other ideas about the entire matters of liquidation. So it will be a good suggestion if the participants can take from this meeting, that every liquidation judgment, please go through that in full. You will understand that in different ways, different courts have looked into matters of IBC and both code and regulation. That also, and also the Companies Act part of it. That also you can get into that, and it will be a real good reading. If you go through every liquidation order is an independent by itself. That way you can really understand the matters much more. Yes, sir. SR sir is back.
Thank you, Mr. Nageshwaran. Any further questions? I find one or two participants. The screenshot is beautiful, but there is no question there, it looks like. But anyway, Mr. Sujit, you have any questions, sir? So Sujit? Okay, I think I'm not audible, or perhaps
You are audible.
audible, okay. Good. Any questions, sir? Any other question? Otherwise, I think we have Ms. Anjali from ICSI available. Hello, Anjali.
Sir, it has been a very elaborative and very wonderful presentation. We will certainly go through whatever case laws we have discussed and any other related case laws. And if required, we can certainly get back to you and we can connect separately.
Please.
Sure, sir. Sure, sir. Thank you very much. So if there is no further questions to our team members, we would like to conclude the presentation today, the webinar. Hopefully, I think the next available opportunity, we'll be able to cover, because a lot of cases are there. Even whatever we have chosen, the number of cases, one might not say that this is a complete coverage of all the areas. Still, we have tried our best to bring before you important decisions, and it will be our endeavor to come back again, another opportunity at the earliest possible moment, with a lot more insight and a lot more analysis of the cases. And thank you very much for the opportunity given to us. Unless any other question is there, I am not able to find the ICSI representative here. Is
Yes,
she
sir.
there? Okay, you are there?
Yes, sir, I'm here.
Okay. I was not able to locate. Is it Anjali or Ankita?
Anjali.
Anjali, okay. Okay, Ms. Anjali, you can also just find out any other question is there from the audience.
Okay. Everyone, are there any questions? Nobody is answering.
No questions.
Okay. So thank you very much for this opportunity, Ms. Anjali, and we look forward to more sessions in the near future. Thank you so much. And
Thank
I thank
you so much, sir.
thanks all.
Thank you so much, Rajenderan sir, Mekla ma'am, Nageshwaran sir, and all the team members
Thank you.
for such a nice session.
Thank you, sir. Thank you, the whole team.
Thank you, sir. Very kind of you. Thank you so much.
Thank you very much, sir.
Thank you, Nagesh.
Thank you very much.
Thank you.
Thank you.